Okay, guys, can you hear me? Can you hear me okay? I see Diane is in the audience. Dan, hi. Can you guys hear me okay? Can you hear me? Can you see me? Yes. Hi, Moni. How are you? Hey, Deb. So glad to have everyone here with us today. In the event you hear torrential rainstorms outside, it's because we have a monsoon coming through. It decided to come through about 20 minutes ago and I had to run outside, so I got totally drenched. I apologize. I'm so glad to see everyone here today. And I want to thank you so much for joining us here and for your support of the channel. This is our very first live stream that we're doing on the channel. Hopefully we will be doing a lot more as we near the start of the trial, which is unquestionably July 30th, 2025. Sorry, Judge Hippler, but it is. My name's Kathy. I'm so happy to be here today with you here on the IndieZone podcast on YouTube. I am a podcaster. I have been for several years. Last year, after learning about the Idaho versus Kohberger case, I decided to convert my podcast, which had been developed to discuss independent things, independent movies, art, music, which I was involved with for a number of years. And I decided to do true crime, which I'm very interested in for a number of reasons and have been for a long time. And the only case that I knew if I was going to make that type of a commitment through trial to had to be Idaho 4. I learned about the Idaho 4 case, and people have asked me, why are you doing this? When did you learn about the case? My husband actually told me about it in November of 2022. He said to me, Kathy, did you hear what happened in, is it Moscow? Is it, we called it Lata County. And I learned about the case and I had to step away because we have children that we put through college. And I believe that the facts of this case are just so horrendous. And stepped away, came back, decided to do the podcast, and then the podcast here on YouTube. The IndieZone podcast is entitled Idaho versus Kohberger. It's on Amazon. It is on a number of platforms, and we just populated all of the events that we did over the past almost 8 months on the podcast here on YouTube. And what we do is we've covered every single public record that you can find on the case, 5 minutes or less, talking about the facts of the case. Then I point you to it because I believe that my viewers, and I have viewers all over the world from the podcast that are following this case and are telling their friends about it in memory of the children that were lost on November 13th, 2022. Just by way of overview, I want to give just a little bit of a background on what happened in this case, and then go into what's occurred during 2024, this past year, and what we're leading into in 2025. The journey started on November 13th, 2022. On that day, the public records tell us that there was a 911 call into the Moscow Police Department. Let me just fix this a little bit. There we go. There was a 911 call that came into the Moscow Police Department, a little town in northern Idaho, which is also the home to the University of Idaho. And when police responded to that 911 call, they found, which just had to be a horrendous vision. This was a 3-story building. There were 2 bedrooms on the first floor, 2 bedrooms on the second floor, 2 bedrooms on the third floor. This was a rental property that University of Idaho students would rent out one of the bedrooms, the common area in between, bathroom on each floor. And it seemed like it was a great opportunity, having gone to college myself. It's great being able to live near campus, which this was just steps away from campus, to have a parking lot out front and some of the other amenities that this house had. But the morning of, just before noon, a 911 call based on the records went into the Moscow Police Department. Officers responded. They went in and they found Xana Kernodle, age 20, Ethan Chapin, who had just turned age 20, on the second floor in Xana's bedroom. On the third floor, Madison Mogan and Xana Kernodle were found. They were both just 21 years of age. There were two other children that were in the house. They survived. Police found what they reported to be a knife sheath, but not the knife that caused the horrendous injuries that led to the loss of these children and the enormous and unimaginable pain that their family members now have to live with for the rest of their lives. Over the course of the next 6.5 weeks, Moscow Police Department, who were the lead agency, because this happened in their jurisdiction, investigated. They called in two other agencies. One national was the FBI, and then one state, Idaho State Police. Exactly 2 years ago today, a warrant was issued for the arrest of Brian C. Kohberger, who was 28 years old at the time. He was at that time a PhD candidate at the nearby Washington State University, just over the state line. He was also a teaching assistant, but he was not from the area at the time, because this was between the Christmas and New Year's holiday when school's historically on break. He was way across the country in Pennsylvania, Commonwealth of Pennsylvania. He was arrested 2 years ago tomorrow, early in the morning, in Albrightsville, a little town nearby the Pocono Mountains. He had a couple of appearances in court in Monroe County, where he was booked. And he did not fight extradition at all. He immediately made the decision to return out west to face the charges. And the Pennsylvania State Police escorted him in the Pennsylvania State Police plane across the country and turned him over. It was about a week later to the authorities in Latah County, where he was booked, arrested, and he made his first appearance the following morning in Latah County Court before the same judge who signed the warrant for his arrest. It was originally Magistrate Judge Megan E. Marshall. For the next year, all during 2023, there were a number of filings on the court docket. And again, we take all of our research from the court docket for educational purposes, and we give our opinions pursuant to the First Amendment of the United States Constitution. This is all based on our opinion for educational purposes. That first year, there were quite a few filings on the docket, and fortunately, the Idaho judicial system publishes this record online, and you can go to the Idaho Courts of Judicial Interest and scroll down to Kohberger case, Idaho versus Kohberger, and you can see the records that are on the public docket as well as the case summary page. So there was a lot of back and forth. In 2023, there was a lot of discovery that was served. Discovery is the evidence that the defense believed that the state of Idaho had in its possession, custody, or control that was relevant to Mr. Kohberger's case. And so that's what discovery is. So there were a number of discovery requests that went back and forth. Everything has been under seal. And on top of everything else, there is an airtight gag order that does not allow the attorneys involved to do the sorts of things that we've seen in other cases that are high profile like this, such as to give an occasional press conference or an interview providing the public with the status of the case. My biggest concern about this case is that so much remains under seal almost 2 years later. Probably the biggest event that happened in 2023 was the return of the grand jury indictment. That happened on the 16th of May of 2023, where Mr. Kohberger was indicted on 5 charges. He remains innocent until proven guilty, or until he is adjudicated guilty at all times under our judicial system, which we should be thankful that we have. that allows us to have such things as due process and requires the government to prove all elements of every crime charged beyond a reasonable doubt. He was charged with first-degree felony burglary, and then the 4 charges of first-degree unalivings of Madison. That's count 2. Count 3 is Kaylee. Count 4 is Ethan. And count 5 is Xana. They were the same charges that appeared on the criminal complaint that was signed by Bill Thompson, who is the Latah County lead prosecutor, or Latah County. And that's what he was charged with also in the indictment, and that is the operative indictment as of right now. So fast forwarding to 2024, what happened this year? Probably the most important event, and the one that was most hotly contested and that used up a lot of time this year, had to do with the motion for change of venue. What is this? This was filed by Mr. Kohberger on January 30th of 2024. A motion is an application for a court order. And so what he asked, and it was Judge John Judge, who was the presiding jurist at that time, was to enter an order changing the venue for this trial from Latah County, because he felt he could not get a constitutionally his right for a fair trial there due to pretrial publicity and other reasons. Now, when you see a motion, which is the moving party's application for a court order, they're asking the court to enter an order to grant that remedy. The other side is entitled to due process, and the state of Idaho objected very strenuously to moving the case anywhere out of Latah County. They felt that he could receive a fair trial in Latah County. This was the jurisdiction where these horrendous crimes had happened. They filed their objection on the 8th of February 2024. They also filed a motion for a scheduling order, which was entered in June by Judge John Judge. Over the course of the next several months, there was a lot of back and forth regarding whether the trial should remain in Latah County or if it should be moved to another jurisdiction. And then finally, there was a hearing on August 29th, 2024. On that day, there were various experts that appeared for Mr. Kohberger, 4 to be exact, who provided testimony live at that hearing why the trial should be moved out of Latah County and not remain there. I was quite surprised, and I give my opinion, that the state of Idaho presented no expert witnesses. They had really fought hard against not moving this trial, but they had no expert witnesses that day. At the end of that very, very long day of the 29th of August, Judge Judge stated that it was going to be probably the most difficult decision of his entire career to decide whether or not to move this trial. And he did not verbally proclaim anything from the bench. Sometimes judges will do that. They'll make an oral ruling and then they follow it up with the paper, the written order. This did not happen. Judge Judge felt he needed to think about it, and he did. And during this time, before he entered his order on the 5th of September, the motions to oppose the entry potentially of the DP, this capital punishment, were due from Mr. Kohberger, and they were rendered. He filed a number of motions in opposition to this penalty of potential sentencing to capital punishment on various grounds that day. He raised a number of issues. He raised that the death penalty scheme in Idaho was vague, that it went against international law, treaties, that contemporary standards posed the idea that the DP should be taken off the table for good, and a number of other grounds, which the state of Idaho opposed. The next day, Judge rendered his order, and he did grant change of venue for the trial. But unusually, he did not say which jurisdiction, if it was going to be one of the 3 that the defense posed, including Ada County, or if it was going to be the county that the state of Idaho was suggesting should be. What he did is he asked the Supreme Court of Idaho to make the decision where the case should be transferred to, And that decision occurred approximately 6 days later, and exactly on the 12th of September, when the Idaho Supreme Court ruled that the venue would be Ada County and that the judge would be Judge Stephen Hippler. Thereafter, Mr. Kohberger was transported from where he had been since January of 2023, which was the jail there in Latah County, and he was taken across the country, or across the state, excuse me, to Ada County, and he was then booked there. Judge Hippler rendered an order scheduling a case management conference, which happens at times when judges want to bring together the parties to discuss various things. And that happened the end of September. And then thereafter, there was the new trial order that was entered October 9th, 2024. And if you have an interest in the case, I really, really recommend that you take a look at that order, because it is the blueprint for everything that's going to happen, that's happening right now, and that will happen in 2025 as we move toward trial in this case. But before that happened, there needed to be rulings on the motions to strike the DP. And that occurred. Judge Hippler held a series of hearings on the 7th of November. And I, for one, he's taken a lot of flack in terms of how he has handled hearings. But I believe that he is really approaching this as almost as though he were an appellate court judge. Because when you argue before an appellate court, there's literally a timer sometimes on the table. And when that clock is up, you're done, you're off. He set aside mostly 20 minutes of time for the death penalty motions for oral argument by both sides, 40 minutes for one of them. He felt additional time needed to be had. But what I try to explain when people try to say, why didn't he give them enough time to argue? Judge Hippler had the motions and the responses and the replies in his possession, and you knew that he read them, and he read them thoroughly from the questions that he asked. And what oral argument should be, at least in my opinion, is you get up, you stress 2 or 3 of your major points, you answer the judge's questions, and then you sit down. That's it. And then the other side does the same, and then the judge makes his rulings, and he did. Unfortunately for Mr. Kohberger, all motions to strike the DP were denied by Judge Hippler, but that does not mean that he will be sentenced to that, because of course he is considered innocent under the eyes of the law until he is adjudicated guilty or he pleads guilty. Also, these rulings were important because in the event that he is adjudicated guilty and is sentenced to the DP, he then has the mechanism to go to the appellate courts and to then make his arguments there. Everything is on the record at this time. Meantime, there have been a lot of other developments in the case, and I'd like to refer to Judge Hippler's, it is called the redacted order governing further criminal proceedings and notice of trial setting. It is dated October 9th, 2024. I have a copy of it nearby because it helps me to remember where we are in the proceedings when I do the podcast and for other purposes. It is called the redacted order governing further criminal proceedings and notice of trial settings. I call it the amended pretrial and trial order, because what Hippler tells us at the very beginning here, any prior scheduling order hereby vacated, capital letters, just in case we don't understand what vacated means. He wants to tell us judge's order of June 2024 is hereby vacated. It's null and void. This is the operative trial order now. And he tells us under section A, page 1, voir dire and trial setting. Now, very interestingly, usually what happens is if you are called in for jury duty, you fill out a questionnaire when you turn up. If you're given a summons, you need to report to Ada County or to Broward County or to New York County, whatever county it is. You're given the questionnaire when you turn up, and you answer questions that are put together by the parties and approved by the judge that's then used for voir dire. And that is the process of jury selection. They need to select not just the jurors who will be presiding and deliberating over the case, but a number of alternate jurors who will be sitting there. No one knows who's the alternate. No one knows who's going to be deliberating, but those alternates are important just in the event that one of the jurors gets sick or has to drop out for some reason. We don't want the trial to end and have to start again, because there's a problem with the number of jurors that are needed in a DP case like this, where there's 5 counts and you have 5 claims. 4 of them are first-degree unaliving of the children, and then first-degree burglary. Jury questionnaires will be administered approximately. Now, this is very, very different than any jury trial order I've ever seen in my life. Redacted, 2025. And we're going to learn later on that whatever the date that these jury questionnaires are going to be administered, it will not be before April 21st, 2025. And we'll go into further in the jury order, the trial order, to explain why. Voir dire, this is the official start of the trial, in my opinion, because you cannot have a jury trial without the panel. The voir dire, which is the process where both sides will then get up, take that questionnaire, ask some questions, and decide whether or not this particular pool member is proper to sit on the panel or should be struck, for example, for cause. What might be an example of that? Someone gets up and says, I don't care what you present, I don't care what the law says, my religion says that you don't take a life, and I could never, ever vote for the DP. State would probably want to strike that person. On the other hand, if the defense finds out that a particular panel member has been involved in law enforcement or has some relationship to one of the victims, may want to possibly strike that panel member. Ideally, you want people who have never heard of this trial before, have no stake in the action, will then look at the evidence that has been admitted into court and then render a ruling in deliberations based on that evidence. I don't know how they're going to find anyone like that, because we know from the information that was provided to us at the hearings by the experts that approximately 93% of the participants in a survey from Ada County said that they heard about this case. But in any event, that is when the trial starts, in my opinion, July 30th, 2025. The next paragraph, I think this is Judge Hippler being very, very organized and ambitious, because he's saying that this trial is going to start August 11th, 2025, and then go through November 7th, 2025. These are 5 counts. 4 counts, first degree unaliving, death penalty case. I don't know how this trial and sentencing will happen in this period of time. I don't even know how you can guarantee that it will start on the 11th with opening arguments. What if the panel isn't set at that time? But in any event, these are the parameters that he has set. Monday through Friday, he's given us the day and times. He's given the disclaimer that he may need to be called away, but he's telling both parties, you need to be prepared to go. If your case in chief prosecution is up, you need to have witnesses ready to go. I don't want to hear that someone is flying around, circling over Boise Airport, can't get in. You need to have a number of witnesses to call. And so what happens is there'll be opening arguments where we can expect to see Bill Thompson, even though this case has been transferred from Latah County, he still remains the lead prosecutor on the case because these horrible events happened in Latah County. And then we can expect Ms. Taylor, she is lead counsel for Mr. Kohberger. What happens at opening argument? They get up, they say, this is what we expect the evidence will show, and we want you, at the end of the presentation of the evidence, we're going to come back and ask you to return a guilty verdict. Or Ms. Taylor is going to get up and say just the opposite. The evidence will not show. You have reasonable doubt here. I'm going to come back at the end of the case and explain why you should enter a ruling of not guilty on these counts. There's a final pretrial conference. That's when everybody gets together. Is there anything that we need to know about? Judge Hippler will make sure that everybody's ready to go. And that is occurring on May 15th. If you go to page 2 of the order, that's where you see the motions section. We know already that the DP motions have been already dealt with. The next sections are the discovery and the ICR motions. These are governed by ICR 12. That is a criminal rule of court. Motions to suppress. We know now that they are set for hearing on the 23rd and, if necessary, the 24th. Why? Because this trial order tells us, paragraphs 2 and 3 tell us that the motions to suppress are going to be entertained on the 24th, if necessary, on the 23rd, excuse me, if necessary, the 24th. What's a motion to suppress? Motion to suppress what Mr. Kohberger is alleging, that some of the evidence that has been gathered against him, such as the CSL iPhone, such as the evidence having to do with allegedly suspect vehicle 1 as being his car, the evidence that was taken from his parents' home in Albrightsville, Pennsylvania, from his apartment in Pullman, Washington, that it was an illegal search and seizure under the Fourth Amendment by operation of the 14th Amendment. What does that mean? You see the 14th Amendment that is a lot of times cited to in the filings. Fourth Amendment, Bill of Rights, no illegal searches and seizure. That deals with federal courts. It's made operative. It's made applicable to the states through the 14th Amendment. That's the due process clause that requires 3 things: notice, opportunity to be heard, impartial judiciary. So therefore, if a state is looking to take away someone's property, liberty, or their life, they are entitled to due process of law. That's why you see the 14th Amendment cited so much by Ann Taylor in the filings. And sometimes Mr. Thompson or the state will do so as well. He also has what's called a Franks hearing, and there has been a lot of discussion in the true crime community and mainstream media and amongst the podcasters and the researchers about this Franks motion. What is this? This is it centers on a 1978 United States Supreme Court case, Jerome Franks versus Delaware. Mr. Franks had challenged some of the warrants and the affidavits, that there was untruthful information that led to his arrest. Trial court denied him an opportunity to be heard on that. Went all the way up to the Supreme Court of the state of Delaware. All appeals were exhausted. Then he gets to go to the United States Supreme Court. It's the same sort of theory that we saw last year when the interveners, the media coalition, attempted to get the gag order. Judge does not like it called the gag order. I'm sorry, the non-dissemination order. To get the non-dissemination order set aside, the media coalition first went to the Idaho Supreme Court. What the Idaho Supreme Court said is, we are a court of last impression. You need to go to Latah County first. And they did. And they intervened. They tried to get the non-dissemination order set aside. They worked really hard, as did the Goncalves family. They also tried to get that gag order, non-dissemination order, Judge, set aside. And unfortunately, in my estimation, they were unsuccessful, and it has remained in effect all this time. What the media coalition were told is, you need to go to Latah County first, and they did. Unfortunately, they were unsuccessful. One of the few times that you saw the state and the defense on the same side in this case. They fought very hard to keep that non-dissemination order in place and to have all of the discovery filed under seal, as well as the responses under seal. We have very information on what the discovery is and what the evidence is in this case. Because of those 2 reasons, so much information is under seal, and therefore it's out of the public realm. And it's because the state and the defense want it that way. If the state, as well as the defense, wanted the public to see finally an image of suspect vehicle 1, we would have seen it a long time ago. So there's questions on both sides. Why doesn't the state want the public to see suspect vehicle 1 if it's played such a big role in Mr. Kohberger's arrest? And why does the defense not want it seen? So you can kind of argue both sides of the equation. But the bottom line is that we are now 2 years, as of today, from the date of the issuance of the arrest warrant, and so much information still remains under seal. I am hopeful that we'll start to see more information disseminated on the public record. If we return to the order here, we have an event that's coming up rather quick. It is the January 9th discovery cutoff date for the defense. The defense just filed their 21st supplemental discovery request this past week. It has not yet hit the public docket. We know that because we saw the case management sheet that's maintained by the clerk of court that it was filed. If you look at the case management sheet and you see a little PDF feature, that means a document is going to be disseminated. It's a public document. If you see a little lock and key, that means it is under seal. The 21st supplemental discovery request is not under seal, but can guarantee what it's going to say. Like the prior 20, it's going to say, we're serving, here comes now Brian C. Kohberger, under signed counsel, and serves 21st supplemental request for discovery, And the items that he's looking for is in attached exhibit. I think we're up to P right now. That's going to be under seal, so we don't know what he's asking for. Same with the state, did the same thing. The only reason why we know of some of the discovery, what it is, and the evidence is because of the motions to compel. That's where some of the information came out. But I wanted to direct your attention because someone texted me, said could not make the live today because of a holiday party, but wanted to know regarding, we just had a filing this past week. It's a motion to compel and for sanctions regarding expert witness disclosures. If we turn to Judge Hippler's order here, page 2, it's under discovery and expert disclosures. It says here that ICR 16b7 disclosures were due, and that means your curriculum vitae, fancy word for a resume, of your proposed expert witness and a report of what they are expected to testify to. That was due from the state to the defense December 18th, 2024. Someone filed a motion to compel and for sanctions. And when I hear sanctions, that could possibly mean someone did not comply or is being alleged to have not complied with the court order. And it might be this order right here that we're holding, because the 18th was the day that the state was required to turn over curriculum vitae of all state expert witnesses for the guilt or the case in chief, which is the first part of the trial, to the defense. When you hear compel and sanctions, that means either there's a lot of violations of the rules, which I haven't seen in this case, and a motion for sanctions. Could be the court order. We're going to find out next week, hopefully, because that is a public record. The state then, the defense then has to turn over their proposed expert witnesses, curriculum vitae, aka resume, and expert reports to the state come January 23rd, 2025. And if you go into the next page, the state gets to offer rebuttal witnesses. And so the question that I had is, how come they get to have their initial and rebuttal witnesses? It's because they bear the burden of proof, right? It has to be at the very, very high, or it should be, evidentiary standard of beyond a reasonable doubt. So they get to rebut the defense's expert witnesses. But how we can tell that this jury questionnaire is not going to be administered until sometime after April of 16th, 2025, is by looking at trial materials. This is under Section D of the pretrial and trial order rendered by Judge Hippler. It says here, proposed jury questionnaires are to be submitted by the parties by a specific date, and then objections, and then he has set a hearing. And that hearing is going to be closed to the public to discuss the questions on the jury questionnaire. So there you go, Judge Hippler. We have figured out, as members of this community, that these jury questionnaires that are talked about on page 1 will not be disseminated until sometime after April 16th, because then judge has to enter an order as to what those questions are going to be. So at this point, we are awaiting a ruling on the Franks motion. That is a very, very crucial defense motion. It's also a motion that Mr. Kohberger is not automatically entitled to a hearing on. The judge has to make a decision whether or not he passes the 5-point test that we just talked about regarding the Franks motion. And we did a presentation just the other day of a federal case that walks you through the 5 points. It's a conjunctive test. Mr. Kohberger could get 1, 2, 3, and 4 correct, and number 5, if he doesn't get his Franks hearing. Franks hearing, what it does, a Franks motion attacks the affidavit that led to the warrant. So we can expect, whether or not Mr. Kohberger gets this Franks hearing or not, he has a number of motions to compel. And you can just imagine, motions to suppress. You can just imagine what would happen if he's successful in 1 or 2 of those motions to suppress. It can change the entire direction of the rest of the trial. So we can expect some fireworks to happen on the 23rd. So at this point, I think that this pretty much takes us to the key events of 2024 so far, leading into 2025. Again, the very first item that's due is on January 9th. Discovery cutoff. Don't be surprised if you see a 22nd and a 23rd supplemental request for discovery, because it's basically speak now or forever hold your peace unless you're able to say why you need discovery in March or April with trial coming up. So with that said, are there any questions? Wow, we got a lot of people in the audience. Hi, Kate. How are you? 20 requests. There's Tony. 20 requests. Tell me there is nothing to hide here. Tony, you bring up a really, really good point. When a party, and of course we don't know because we're not privy to the 20 supplemental discovery request, the 21 supplemental discovery requests and the responses. And what they're not supposed to be doing is asking for the same thing over and over again. So ideally, when you serve discovery, your initial discovery request, you might get some information that says, okay, I now need to ask for something else. Or your investigators might be out there pounding the ground, and they find out, hey, we got to talk to this person. We need to ask the state for this. That's what a first, a second, a supplemental is, additional materials. You don't ask for the same thing over and over again. But the proper thing is to go to the other side and say, why are you objecting to, I believe that Mr. Kohberger requires this information in the defense of his case. And will it lead to discoverable evidence? It's a really low standard to meet in order to win on a motion to compel if it's relevancy that's being raised. There might be privacy, or as we saw in the IGG, what a battle that was. We had an immense battle over change of venue, but the IGG evidence was the subject of the third motion to compel. They asked for that information. The state raised objections. There was a hearing that was held before Judge, and then he came out with the long order that he did in October of 2023 that named as the only informants that we know about as admitted to by the state of Idaho being the people on that IGG family tree related to the testing of the sheath and the organizations that provided that type of testimony. They convinced the judge that they are informants. They said, hey, they're not what you normally think of informants, somebody that comes in, sees something, hears something, and then goes in and agrees to confidentially help the state. There might be an exchange. If it's somebody that has some criminal charges against them, they may testify in exchange for some leniency or promise of leniency, not always, but that's who people historically think of. Now, is there a possibility that there's more informants than the people on that family tree? Yes, of course. We just don't know that because the record does not state that anyone else other than the members of the family tree and the organizations that people go to in order to get their DNA tested for genealogical purposes, they're considered informants and they're under protective orders. That's all we have at this point. Any other questions? We're waiting for the prosecutor to provide a summary of their yes, that's right. That's true. What I think, and again, I give this as an opinion, when I see sanctions, that tells me an order has not been complied with. And so I look at this order that Judge Hippler entered, and we see that the state's expert witnesses, not just their CVs, but what they were expected to testify to. And we've seen things like this along the way from the defense's proffered experts. They wanted to have 2 additional experts testify at the DP hearing. Judge Hippler had what their intended testimony was going to be, and he made the decision that he didn't really need to have them on the stand. He had what he needed because they provided their CVs and what they were going to testify at hearing. Same difference with the experts. Now, just because an expert is proffered doesn't mean that they're going to testify at trial. They're going to have to go through a test. They're going to have to come before the court. The court's going to have to make a decision, and that can be gleaned from the CV, the resume, and the expert report. So these things are really important for a number of reasons. There's 2 types of witnesses that you have at a trial. You have fact witnesses, people who saw, heard, know things, have firsthand knowledge. And then you have expert witnesses who either side, defense and state, are going to say, hey, judge, we got a lot of information here. The CSLI stuff is way over anyone's head. We need someone like, We believe it's going to be Cy Ray. It may not be. They may have contracted with someone else. But as of right now, Cy Ray, who testified at a hearing earlier this year, may be a defense disclosed expert witness. But the defense is going to have to produce to the state of Idaho Mr. Ray's curriculum vitae, where his background, training, skills, knowledge, publications, degrees, work experience would be listed along with his expert report. And then they have to go before Hippler. And Judge Hippler will make the final decision if any of these experts, or if none of them. Sometimes you get entire groups of experts stricken as it's junk science. It's not really relevant to the case. So we're going to have to wait and see as we get closer to trial. Any other questions regarding anything that we, does Ada County Court release the papers sooner rather than later? I can't access from Europe. Sorry about the translucent. I'm going to be honest with you. I would have thought, and I'm here in the United States, translucent, I got the same problem. You know, I'm used to, if I see something on the case management page, which is the clerk of court saying that a document was filed on the 12th of December, you would think that by the 15th, the 16th, the 17th, if it's a PDF and a public record, that it would appear on the public docket. There's been some delays in the release of some of the public records on top of all of the items that are under seal. So it just seems as though there's a delay. But translucent, if you're not able to get the records, please listen to the podcast, because we give you a synopsis of each public court filing in 5 minutes or less, and then tell you where you can go on the docket to find it if you can. There's one platform, it's called Listen Notes, that I think is really helpful for people that are doing research. This docket's a nightmare. It has become so large, it is unsearchable. Sometimes the title of the documents, like if you're hearing redacted order governing further criminal proceedings and notice of trial setting, how are you supposed to know that this is the pretrial order that's setting things such as when motions to suppress evidence are set for hearing? So what we do at the IndieZone podcast is 5 minutes or less, give you the bullet points, tell you where the document is. So if you want to do research, let's just say on IgG DNA, you go into Listen Notes, and I think Apple also has the search engine. You plug in those terms, and it will pull up all of the records that you can then go to the court docket and pull them up. But yeah, it just seems like it's taking a little bit more time to get the public records on the docket than we saw in Latah County. It could also be because it was a much smaller county. Okay. Oh, thank you, Translucent, that you are listening. I do appreciate that very much. Were there any other questions that anyone had regarding the status of the case so far? The hearings that are coming up so far. Just because Judge Hippler did not set something for hearing, it does not mean that one of the parties can't come forward and request either a case management conference. Certainly, either one of the parties could at any time ask for a case management conference to be convened. The question is it going to be public, or is it going to be sealed hearings? We've seen a lot of sealed hearings. We've seen a lot of hearings that the public even didn't have notice that were held. And we find out afterwards that these hearings were held when there's some sort of a ruling on the public docket. There was a hearing that was held that is, in my opinion, very bizarre. December 11th, it was a hearing before Judge Stephen Hippler. We know that it was a defense hearing because one of the defense counsel said it, and it was on motions, plural. That means more than one motion application for a court order. The titles of the motions were not there. We don't know what these hearings were about. We do know that the defense stated that they intended to possibly bring in some live testimony, and the state did not even receive a copy of that notice of hearing. Now, we can go out there and speculate till the cows come home as to what that was all about, but that hearing was held, and the minutes are under seal. The minutes that would ordinarily tell us what time did the hearing start on the 11th, what time did it end, what motions were called up, who was there, who said what, did the court rule on anything, granted, not granted, reserve ruling. We have none of that information because it's all under seal. What do you guys think about this issue of the documents under seal? My major concern with the case is the what I call the Mount Everest. This is my opinion. I give it as the First Amendment, freedom of speech, freedom of press. I think that a lot more information is under seal than should be. You know, we hear all of and they're all good reasons. Mr. Kohberger is 100% entitled to a fair trial. That is his constitutional guarantee. The state of Idaho raises, you know, if we disclosure of this information could then disclose the identities of people whose privacy, they have privacy interest or law enforcement techniques. But it just seems as though the First Amendment always gets pushed in the back seat, the public's right to know. And people say, but Kathy, this is pretrial, it's not trial. But then I say, there's a lot of trials that at pretrial, you get information from the state or law enforcement pre-arrest and even post-arrest will come forward and say, this is the guy. Here's why we think this is the guy. Public safety concerns. No, you don't have to be worried about some maniac on the loose. This is the guy, and here's why. We can't give you anything, but we'll give you a couple things. You know, I go back to the 14th of February of 2018. There was an atrocity that was committed at Marjorie Stoneman Douglas in Broward County, Florida. 19-year-old former student walked in, and in a matter of minutes, 17 people were unalived. As young as 14, in their 50s, it was 3 faculty members, 14 students, another 17 were wounded, 34 people. Nicholas Cruz was picked up and a lot of information was put out there. They had surveillance. This is him. This is the reason why we think it's him. This is why we think he acted alone. He was arrested. He pled guilty, and he agreed to plead guilty to all charges if they would take the DP off the table. State of Florida said, no, you have unalived more people in Florida than Ted Bundy and Danny Rawling combined. We're going for DP, capital punishment. If anyone should be subject to capital punishment, it's you. Everything, there wasn't a lot that wasn't under seal. Guess what? He got the verdict he wanted. He got a fair trial at sentencing. He got life in prison, which was exactly what he wanted. So I'm hopeful that we go for, and I see Kate saying, I'm all for transparency. A lot of people are saying the same thing, that we're hopefully as we get now, this is 2 years today since the warrant and the order finding probable cause was rendered. 2 years ago today. 2 years tomorrow came the arrest. Let's hope. You know, Judge Hippler had asked he put in a process that if you want some information, you have to fill out a form, you have to send it. And some people have said that they are, and they're waiting for some responses. Hopefully we'll start seeing some things. But again, you know, my opinion, it's both sides. It's not the state only. It's not the defense. It's both sides who want that non-dissemination order to remain in effect and who want these documents under seal. Do we have any other questions? Cyray has always offered his expert services, right? Yeah, Cyray, this is the first time, isn't it, that Kate is bringing up defense expert at hearing. Wait to see if he's going to be the notice defense expert for trial. This is the first time he's testifying on behalf of any defendant ever. He's got a strong law enforcement background. But then there's others that say, you know, he was struck from being an expert witness once. He might be struck again. We have to wait and see with all of these things. Do we have any other? Yeah, it's a rumor. There's some rumors been going around that Mr. Ray is not necessarily going to be defense trial expert. Rumor. There is nothing in the record at all that would confirm that statement. Any other questions? Okay, the standard, it is the beyond a reasonable doubt. That is much higher than if this were a civil proceeding. If this were a slip and fall, let's just say you go into a supermarket, you slip over something that's been allowed to remain in an aisle for a week, and you break your hip. 51% is what the burden is in a civil case if you sue for negligence. It is beyond a reasonable doubt, which is a much higher standard. So what the state has to do is proffer enough admissible evidence that gets them beyond a reasonable doubt on every element of all 5 of those charges. This is why these motions to suppress are so critical, and why both sides are going to fight. You're going to see it, guaranteed. You are going to see a battle. Thank you, Truth and Justice. I appreciate your kind feedback. I really, really do. So expect a battle. We're going to wait to see what happens on this Frank's motion. Again, I published a video just a couple of days ago of a federal court proceeding. These were claims that were brought against a man who lived in, is it Nez Perce County? It's not very far from Latah County. It was a family dispute, as sometimes goes very bad. He wound up with multiple federal charges, and his counsel was attempting to get a Frank's hearing. Okay, we have, does MSM have preference on getting copies of things from the courthouse before they are logged to the public? I don't know if they have a preference. You know, Deb raises, Deb is raising, does MSN have any preference on getting copies of things from the courthouse before they are logged in for the public view? I don't know. You know, I've seen a couple of things, including this past week, from a member of MSN that relates to this motion to compel and for sanctions that suggests you may have a little bit more information than we do as a member of the public. So who knows? But at this time, we're supposed to be getting the information off of the public record once it hits the court docket. And that is going to be a very, very, very interesting motion to compel and for sanctions. Just imagine if someone disobeyed Judge Hippler's order. He does not seem like someone that you want to mess with. If he sets a boundary and someone intentionally violates it to prejudice the other side, I don't think he would be too remiss of entering sanctions against them. Some have asked, do you think if this is the state that the DP could be taken off the table as a sanction? Now, first, we don't know if this is a state or a defense motion. We're making an educated guess because of the court order and the dates. That would be a really extreme thing to do in terms of a sanction at this point for violation of a court order to provide possibly expert reports. It's my gut. My opinion is maybe the names and the CVs were, but it's not, the expert report wasn't sufficient enough as deemed by the other side. And that's why they're going to court to compel, motion to compel. Judge, we want you to order this person to turn over what they were supposed to turn over. That is what a motion to compel is. And then for sanctions, many times it's for violation of a court order. There's another interesting document, a subpoena ducis tecum that we noted, that is also a public record that was served, I believe it was the 26th of December. It still has not appeared on the public docket, but that's a subpoena for someone to turn over, to appear and to bring some records. I believe it's one of the parties have served it. We don't know if it's the state of Idaho. We don't know if it is the defense, but it is a subpoena ducis tecum. That means Latin terms, bring with you. You need to bring forward some records. So we'll find out what that is about. Hopefully next week, that document will appear on the docket. And again, go to look at what's been served so far. Go to the case management summary. It's 63 pages right now. It goes back to the days of Latah County, and it will tell you all of the key events that are on the docket. And again, if you see a PDF, that means that's a public record. If you see on there the little lock and key symbol, that means it's under seal. So we're waiting for a couple of PDF documents to hit the docket this next week. Are there any other questions that anyone has on the proceedings? We have quite a nice turnout today. I really appreciate it. So at this time, I want to just thank everyone. I just wanted to do a brief overview of the case right now, what we know so far and what we're going to know. We're in it for the long run. That's the commitment that we've made. We're going to be here both on YouTube. So please continue, like, comment. We have also on the community page, we offer some, what we call them, pop quizzes to test our knowledge because the docket is so long right now. And a lot of people have been doing really well on those. We'll give an update in a video as to what the correct answers are on the community page. We just put one up this morning having to do with due process. So if you have an opportunity, please go ahead and take that. And please like, subscribe, share, comments. Everyone's viewpoint is welcome here. Wherever, my own family, we are all over the place in terms of what people think at this point of the proceedings. So everyone's viewpoint is welcome, appreciated. But again, we focus on the public record, and that's where a lot of our content, all of our content really does come from for educational purposes, to discuss this case that looks like they're going to be going to trial July 30th, Judge Hippler, not August 11th. Okay, if there's no other comments or questions, I want to conclude this first live. We'll be doing some more in 2025. I want to wish everybody a very happy and prosperous new year. And thank you so very much for your time and your attention today. Have a great day.